this is enough for today. And now we'll go ahead with Sir's session. Pushkar, sir, please proceed with your session. Thank you so much for being with us here today.
Yeah, thank you, Advocate Ruchi Mevane. So most of the people present here today, warm good morning. And I just want you all to know that Advocate Ruchi has been my schoolmate. We were in the same school, so we both studied in the same English school. So it is an honor that you are having me here today on the special occasion of the Women's Week, and it is destined. We were approached a couple of days ago by Advocate Abhishek Jagtap sir and Vijay for the purpose of delivering a lecture which is specific to the topic of women, and what else can be the occasion other than this one. So thank you very much for to LDF as well as this special Sunday bulletin, law special bulletin program for having me here as a guest. And I want you to all just concentrate on one thing, that says LDF is already organized a convention with respect to case writing and case analysis. I believe that the lecture that we will have today will give you an insight as to there is some topic that you can really explore and that truly needs a debate, because the moment I start with the background of the case that I share with everybody from my own perspective. I might be wrong here, but you can always correct me, and that is the purpose, of judiciary, that there are several ways to look at a matter. So before I begin the lecture, I would request Ruchi ma'am to just switch on the PPT that we have made specially for this program. Ruchi ma'am?
Yes, sir. Just give me 1 minute.
Yeah. It's sent to you on your mobile phone.
So there are some participants who are saying that the voice is not audible. So could you please maybe enhance
from
your voice?
My end?
Yes, your end, sir. It's breaking a little bit. It was also breaking from my end also. Yeah. So I think maybe, now it's better. Yeah. Now at this position, it's better.
Better now?
Yes.
Yeah. Okay.
Just give me 1 minute. I will open up the presentation here.
Yes, please.
Yes. Is this visible? Is the presentation visible?
Oh, yeah. This is visible.
Good. Yeah. All right. Good.
Yeah. Okay. Yeah. Everybody can see it, right?
Yes. There's no comment. Yes, it's good.
Yeah. We'll move to the next slide, please. Yeah. So before beginning the session on POSH Act, I want everybody to understand a case that has been the reason, or we can say the stepping stone for the introduction of the POSH Act or the Vishaka guidelines. I would definitely go into the Vishaka guidelines, but there is this case that you have to understand. Now, this case, my friends, it's regarding the Babri Devi case of Rajasthan, and there are ample of articles available, but you can always go and explore through internet. You can get a better vision. But I am going to discuss this case only in perspective as to what, as an advocate, we have to see. Now, my friends, this case is regarding a female, Sathini. She was a Sathini. Babri Devi is a story about a woman who belongs to a backward class of society, and she basically got married at a very young age, and she did not have much funds, we can say. She did not have a proper background, we can say, or she did not belong to a proper strata of a society which did not have much recognition. Now, since we are staying in a city, observing things based upon a caste difference are nothing new for us, because there are laws in place which are already the same. But we have to understand Babri Devi's case from a perspective that this case belongs to a small village in Rajasthan. Now, that village, technically, there are people amongst whom 80% of the people belong to the higher class of society. Now, if you do not know what a class difference is, you should seriously visit the backward class villages where there is ample of difference between two classes of people. Babri Devi belonged to a small strata of society. Now, that strata, only because the government of India in the year 1990 introduced a rule that we require the law of inclusivity, and we require men from women from all the society, all the backgrounds, all the castes to have a representation. Now, along in that law, she got an opportunity to come and join a women committee. And that women committee was for the development of women and child and against prohibition of child marriage act. Now, this is a case in Rajasthan where there was a sarpanch and he belonged to a higher class of society. I do not want to name any specific caste or religion of any person, because we are lawyers, and it would not be good to recommend a society's name or a caste's name. So you can better understand. We are all lawyers of the. So a person who is a sarpanch in that locality, he wanted to get his 9 months old child daughter married to a person whose age was also 5 to 6 years. Now, both these families belong to a higher class of society. Whereas Bhavri Devi, her only job was to go and stop the marriage, nothing else. She tried to convince both the families. The very first thing that she was asked was, which caste do you belong? Now, since she did not belong to the same caste as that of the Sarpanch, she was not entertained. Secondly, she belonged to a class or caste which was far more unrecognized, I would say, or demeaned or looked after upon with lower category. She was not entertained, she was thrown out. So ultimately, you have to understand that the committee that she belonged to had actually 12 members, out of whom 3 were women. And only Bhavri Devi was the active person in the entire committee. So this Bhavri Devi, without having any of the idea what was going to happen, she immediately approached the local police station. Upon approaching the local police station, the police intervened only because that was a daytime, and these are facts which are there on the case. It was a daytime. The police accompanied her to this place. The marriage was stopped there. Bhavri Devi found that it was a good success and she was very happy. And then she came back. And it was a special occasion on that day for the Sarpanch family, or his specific caste and religion. Specific day was there. The moment Bhavri Devi left from the spot and the police left from the spot, at the night, the Sarpanch eventually got his 9 months old daughter married. So basically, all hue and cry for nothing. So Gauri Devi, technically, she might have went there and tried to stop something, but she could not. Eventually, that happened, and maybe that was destined to happen. Second thing comes, Gauri Devi came to know about it, and Gauri Devi registered a case. How did Gauri Devi register a case? That was the point of it, which was basically which angered the entire community of the Sarpanch. So what they did, 5 people from the committee of Sarpanch, there were technically 14 people. Now this is a case documentary which you can definitely go and check, but there were 14 people who tried to encroach upon the farm of Bhavri Devi and her husband. Her husband was hit on the head with a brick. He fell unconscious to the ground. He was tied to a chair, and 5 people, including the Sarpanch, committed sexual assault on Bhavri Devi. Now, it is yeah, Ruchi, I guess somebody is saying that my voice is not audible. Can you
Yes,
confirm it?
I think no. In some portions it is audible. I think it's because of the microphones that you're using. Probably
Just give me one.
yes,
Just
yes,
give me one time.
yes.
Yeah, am I audible now?
Yes, pretty clear. Yes, yes, yes.
Yeah, right now.
I cannot hear anything from you right now. Yes, yes, now
Just
it's
give me
better.
one.
Yes, it's better now.
Now, much better.
Yes, good. Yeah, that's good. Yes,
Yeah. Now I hope I'm audible enough, everybody.
yes, it's
Yeah,
pretty clear.
yeah,
Pretty clear.
yeah.
Yes,
This. I apologize for the Bluetooths. Yeah,
no problem. It's fine.
yeah. So basically, what had happened is that this case where Bhavri Devi was, I believe you must have recollected the scenario where eventually the marriage took place. The Sarpanch got his daughter, 9 months old daughter, married off at the very midnight hours, and Bhavri Devi could not help it but go and register an FIR. And basically, that FIR also was not registered; it was a mere complaint, and this angered the Sarpanch and his community. Yeah. So thank you. So these committee members, the Sarpanch and 5 of his family members, so basically 14 people were total in all present at the spot when this incident took place. But it is a well documented case story. But ultimately, Sarpanch and his 5 of the male relatives approached directly, encroached upon the land of Bhavri Devi's farm, and they attacked Bhavri Devi's husband. They hit him on the head with a brick. They tied him up in a chair, and Bhavri Devi, right in front of the eyes of her own husband, came to be raped. And everybody raped her technically. That was a sad part because this happened early morning at about 11:15. This incident took place. Bhavri Devi and her husband were left unconscious till evening time. It is somewhere around 8 or 8:30. Eventually, Bhavri Devi and her husband woke up in a conscious state. They did not have anybody around, so they started to approach the police station. Now, what had happened? They went to the police station. The police, how did they go to the police station? Now, that is an interesting part because there are two different views to look at it. First of all, Bhavri Devi did not own any vehicle. And remember this, we are talking about a case in 1992. So there are no taxi services. There are no, what we say, Tanga services. Bhavri Devi's husband's, the only cycle was also broken into pieces so that he cannot travel anywhere. It is because of the bravery of Bhavri Devi's husband that he carried Bhavri Devi on his shoulder and walked for 23 kilometers to the police station. The first police station that he approached did not have the police. The police station, entire police station was empty because it was midnight hours. And once again, they had to go a further distance to approach another police station. Where they went, they reached there after the midnight. Say, for an example, about 1 to 30, they reached there. The police present over there did not have a lady police officer. Now, this becomes interesting. For all the people who are interested to write the essays, you have to think from a perspective of a 1992 year. They did not have a lady police officer present in the police station. They asked for a lady police officer, which was denied. Second thing they had to do was, they asked Bhavri Devi to remove her clothes and to show how she got raped. Now, this is a humiliation. FIR was not registered. Now, remember this thing. Whenever the case of a rape takes place, a lady has to approach the police station and the police are duty bound to register the case within 24 hours, and within 24 hours, her medical examination has to be done. Now, if this incident has taken place in the afternoon hours of 1:30, she approached the police station after 12 o'clock in the midnight. She was basically, all the delay was caused by the first police station she approached, then the second police station that she approached, and ultimately the police refused to take an FIR because the police found the story that a husband carrying his wife on the shoulder for 23 kilometers is unbelievable. This is the sad state of affairs. So ultimately, one of the committee members who was working as a Sathini with Bhavri Devi, she had a quite adequate knowledge about the law. So she recommended her that we have to first approach the Jaipur hospital that was by far 56 to 57 kilometers away. So she took Bhavri Devi to the hospital in the morning. Now this is around 8:30 a.m. She was still in a state, and within 24 hours to get the medical examination done. Now, what sadly happens is, Bhavri Devi reaches the Jaipur hospital, and Jaipur hospital officials refuse to conduct the medical examination. Firstly, stating the reason that we do not have a female doctor to check her. Now, that is a rule. Now, I don't think. Now, this is debatable. Understand this. The Jaipur hospital that she first went to did not have a lady doctor, which is understandable because the Supreme Court guidelines were still in place that whenever a victim of rape comes to the hospital and her medical examination has to be done in presence of a lady doctor. So now this is debatable. You have to understand it from a perspective of 1992 and a village. Now, since the doctor present over there refused to do the medical examination, now she has to further go into the city area, again 20 kilometers from the Jaipur hospital to the government hospital. And over there, once again, she reached over there at about 12:30, well within time of 24 hours. And over there also, the medical examination was not done because the doctor present in the government hospital told her that she will either have to file the FIR first or she will have to get the orders of the magistrate in order to enable the doctor to do the medical examination. Now, this friend of her, Sathini, She accompanies Bhavri Devi to the local magistrate. Now, after going to the local magistrate, a lot of time is passed because the magistrate has to conduct the proceedings before him. Then he has to go through the application. Then he has to call the report of the SP. Then he has to call the report of the police. Then he has to form an opinion. Then he has to deliver a judgment. Now, that is a lengthy procedure. And we have seen as advocates what is the sad state of affairs when you file a complaint and how much time it takes for a matter to reach. But in such a sensitive case, it was the duty of the magistrate to look at the matter with utmost priority, but sadly, once again, it did not happen. A time of 52 hours was already lost, and then the magistrate gave the directions to the government hospital to conduct the medical examination. Ultimately, based upon the order of the magistrate, she was taken to the government hospital, and once again, sadly enough, the medical examination was conducted by a male doctor. 52 hours, my friends, is a lot of time. And unfortunately, nothing conclusive came to be found on the body of Bhavri Devi except for the injuries and the semen that was collected. You already know what has happened with the case of the POSH matter that Pune faced, how the government hospitals have shown their true character when it comes to wealthy people. The sperm samples were not found. That is the story that Bhavri Devi had to face. Now, eventually, medical examination was conducted. Subsequently, one local newspaper, and believe me, that local newspaper, maybe it had only 400 or 500 readers. One local newspaper covered the news of Bhavri Devi after 78 hours. Based upon that story, the opposition party, the party who is not in power, they raised the topic on the issue of safety of women, and one NGO, Vishakha NGO, they raised this topic and they immediately approached Bhavri Devi. They succeeded in filing the FIR for Bhavri Devi. A FIR of 376 along with other sections of the IPC came to be registered against all the persons who were involved. Investigation was made. A charge sheet came to be filed before the Rajasthan District Court, and the trial stood for 5 years. Now, one interesting thing. You have to think as advocates. Yes, it is true that when a rape victim is standing in a box, whatever she deposes to the court has to be considered as a prima facie proof of what has happened with her. Now that goes into the Indian Evidence Act, section 114A, presumption of certain facts. So if Bhavri Devi has claimed that a rape has taken place, the court prima facie has to believe that a rape has taken place unless otherwise proved by the accused. So the burden of proving the innocence has already shifted to the accused persons. Now what happens in this case? Prosecution had a very simple story. They had the explanation of all the things which caused this unnecessary delay. They stood their ground. All these factors should have been considered by the court. But what has the court observed? And I have, you can see on your screen, the trial court judgment. Now these are interesting. The first is the village head cannot rape. Now this is there in the judgment. You can go and check the judgment. How did the court reaches a conclusion that a village head cannot rape? On what basis? Does it make him important? Technically not, but how is this observation made? The second observation is men of different castes cannot participate in gang rape. This story was basically considered that the cross-examination was conducted and Bhavri Devi was asked that were all the men belonging to the same upper caste. But naturally, 5 people have raped. 4 of them were family members. 1 of them was their worker. He did not belong to their family. So Bhavri Devi had stated that 4 people belong to the same family. 1 did not. The observation is taken that another person did not belong to their caste. That is why men of different caste coming together and raping a woman cannot happen. Now, this is an observation, now, which is very shocking, and we as advocates can relate that it is unjust. Elderly men of 60 to 70 years cannot rape. Now, my friends, whoever you might be practicing in criminal field, I want you to tell that once a accused person in a rape case is taken for medical examination, the doctors doing the medical examination has to first find whether the person who is the accused is potent or not. Now, if the medical report is saying that he is potent, then he has the potential of sexually enforcing himself upon a victim. But the court observes that the elderly men of 60 to 70 years cannot rape. Now, this is another shocking incident. The fourth observation is a man cannot rape in front of a relative. This was with reference to the Sarpanch himself and his nephew. The story taken by the court is that, based upon a suggestion which the defense had put up, that is it correct to say that one of the accused persons was the nephew of the Sarpanch? And she obviously had to say yes, because that is the fact. But how did this conclusion reach to that a man cannot rape along with his nephew upon a woman in presence of each other? This observation itself is perverse, I believe, in my opinion. Fifth is a member of higher caste cannot rape a lower caste woman because of reasons of purity. Now, this is extremely shocking. If you go through the NHRC data, you will find ample of cases where the people from the upper caste have forced themselves upon women of lower caste only upon the category of caste difference. And yet, shockingly enough, the judgment was reached. The sixth is Bhavri Devi's husband couldn't have quietly watched his wife being gang raped. I began my story by saying that Bhavri Devi's husband was hit with a brick. He was made unconscious and then he was tied to a chair. Despite these facts being on the record, despite Bhavri Devi stating entire facts on the record, such an observation was made. Ultimately, all the 5 accused persons were given acquittal. Unfortunately, no reference was drawn with respect to the other 9 persons who were technically present over there. Unfortunately enough, an appeal was made before the High Court of Rajasthan, and if the facts are to be believed, based upon what I have searched in the case, only 2 hearings have taken place so far in this, how many, I would say 28 years. So you can see the sad state of affairs that we are going through, and it is an unfortunate event, and it still breaks my heart to see such atrocities happening on a woman victim, and she has literally nowhere to go. Now, what has happened during the pendency of this case in the year 1993, when Vishakha entered in the matter and who helped Bhavri Devi register a case. So Vishakha is an NGO along with 10 other NGOs. They approached the Honorable Supreme Court of India based upon Article 14, Article 19, and Article 21. Right to dignity, right to life, right to free, right to right of being treated equally, right of equality. And their 2 prayers were that the investigation with respect to Bhavri Devi may kindly be given to CBI. And the second prayer was that there should be uniform guidelines with respect to the United Nations Charter, for which CEDAW law. Ruchi ma'am, can you go on the next page, please?
Yes, sure.
Yeah.
1 minute.
Yeah, so this is so basically Vishakha versus State of Rajasthan, the citation I have placed on record. So this was happening before Justice J.S. Verma, Justice Sujata Manohar, and Justice B.N. Kirpal. So what had happened during that time, that there was a UN Charter circular on international human rights law, which was the Convention on Elimination on all forms of discrimination against women, which is the CEDAW law. And it was Sujata Manohar's role, who went to Beijing to attend the conference, and over there the case was discussed. And at that time, that trial was undergoing, because the investigation had taken place, a charge sheet came to be filed, and this Vishakha was technically fighting for a further investigation. Now, there is a difference, my friends, all the lawyers present over here. There is a difference between re-investigation and further investigation. Once an investigation has taken place, there cannot be a re-investigation. It will always be a further investigation. Remember this thing. So there is no technical concept of re-investigation, because that goes against the rights of the accused. Because if the police have not found anything in the first investigation, doing a re-investigation is technically causing him a double jeopardy. So it is always further investigation. I get to see this in a lot of moot courts where the students come with a theory of re-investigation, that there is no such thing as re-investigation. It is always further investigation. You have to carry forward your investigation from where it has stopped. It may go into another set of facts which might be rediscovered, but that still will be further investigation. So for this further investigation, an appeal was made, a writ petition was made before the Supreme Court. But eventually, during the pendency of this case, this petition, during this hearing, the Rajasthan government itself gave the entire matter for further investigation to the CBI. So technically, this petition had become infructuous. But it was the understanding of Justice J.S. Verma, who was more keen on hearing the second prayer. The second prayer was there should be uniform guidelines and the government of India should be compelled to enact a law which is in accordance with the CEDAW and which enacted a law where the woman can feel safe, they can have the equal pay, they can have a equal remuneration, they can work with dignity, they can work with respect, and they will have a separate identity. Now, it is because of these efforts that J.S. Verma was more keen on hearing the second prayer. So despite the petition being infructuous by using the discretionary authority of the Supreme Court, Honorable Supreme Court gave the opportunity to Vishakha NGO to have their word, and based upon which, and due to the efforts of Justice Sujata Manohar's role in 1997, she gave the directions, and the Supreme Court, and which is one of the form of a case, despite there being no law in existence, but because India is a signatory to the United Nations, the Supreme Court, by using its discretionary power and authorities, enacted the Vishakha guidelines. And these Vishakha guidelines were guidelines which had to be in use for as long as the government of India does not come up with a law. So you can understand it is a clear-cut guideline given by the Honorable Supreme Court. And as law students, everybody of you might be knowing the discretionary powers of the Honorable Supreme Court are vast. That is exactly why the laws of Section 497 of adultery came to be scrapped by the Honorable Supreme Court. So that is a special power, special jurisdiction enjoyed by the Supreme Court. Supreme Court enacted these guidelines, and we, being the dignitary, we had to follow the 1993 Charter, which is the elimination of violence against women, and it happened on the 25th June 1993. So we'll move on the next slide, please. Now, these are the Vishakha guidelines. Now, these Vishakha guidelines, my friends, these guidelines are as it is enacted in the POSH law, which I will be discussing ahead. But you have to understand what exactly is Vishakha guidelines. Now, understand this position. There are no laws in place. There are no existing laws in place with respect to POSH Act, which we read today. But Honorable Supreme Court, along with the recommendation of Vishakha, along with the recommendation of Justice J.S. Verma, laid down that it is the duty of employer, company, or other accountable persons in the workplace to prevent sexual harassment. Now, it is an interesting topic. Does it mean that the employer has to be either a company? Does it have to be a public company or a private company? No. The definition goes beyond that. Say, for an example, you are having your house and you want to hire a housemaid. That housemaid is working at your house. She is also protected under the Vishakha guidelines. Understand this. There is a difference. The moment we say that protection of women from sexual harassment at workplace, so understand this. We are talking about women in general. The two things that are necessary to be seen are that there has to be a woman and there has to be a workplace. Where she works has no relevance. Under which circumstances she works has no relevance. If she is employed, that law and these guidelines will extend to her. That is the first thing that we have to understand. So this Vishakha guidelines is extending to all the working women. Now, if you are a female advocate and you are working in Pune court, these guidelines are applicable to you as well, because you do not have an employer there. You are working as a private entity, you are working as a serviceman, you are giving your professional services. And if you feel that you are being sexually harassed or sexually intimidated or sexually pressured, sexually forced, or being welcomed in an unwelcomely manner, then you have a right under Vishakha guidelines. And who do you approach? The first thing, because there is no employer, there is no company, there is no such environment. At that moment, my friends, you have to approach either the bar association, that is your jurisdiction, and the second thing is the district magistrate. Now, I will come on the law in the POSH, because that has come into the existence subsequently. But you have to understand that every woman who is working, Vishakha guidelines is her savior. And unless and until you are aware about your own rights, there is no point of going into the POSH law, because Bhavri Devi is technically the stepping stone why Vishakha guidelines are in place today. The second is sexual harassment includes. Now, what does it include? It includes a physical contact and advances, demanding sexual favors, sexually colored comments, displaying pornography, any other unwelcome physical, verbal, or non-verbal behavior, and sexual nature. If you all remember, and you must have read in the newspaper, there was a news that covered that if you look at a woman for 14 seconds, a FIR will be registered against you. That is the most stupidest article I have ever read, and I do not want to name any of the newspaper articles for that. Basically, it is upon the intent of a person. If a person who is having a cheap mentality and he wants to look at a woman having a cheap mentality, then I don't think so there has to be a specific time for that. If he looks at a woman and he does not have a good intent in his own eyes, the time doesn't matter. And if that look of his is making a woman uncomfortable, then that is a harassment. Whether it is sexual in nature, it is uncomforting in nature, but that is still harassment. So there is no such law that if you keep looking at a woman for 14 seconds only, then an FIR will be registered. It is not the law. Don't rely upon such articles. The law is very clear. If a person having a sexual intent or a bad intent looks at a woman with a negative energy, and the woman is not being feeling safe in that energy and she is discomforted with that, that amounts to sexual harassment, and that is a settled principle of law. Now, these guidelines apply to all the persons, whether it is public or private, as I've already stated. But there has to be a documentation. Vishaka guidelines does not mean that you can go and file something orally, as it is already read in the old law of CRPC, where under section 154 subsection 1 of CRPC, the police orally, based upon an oral complaint, had to take down the complaint. The law with respect to Vishaka guidelines is different. You want to file a complaint, the complaint has to be in written nature. And where you file the complaint, the person who is going to entertain your complaint has to keep the entire documentation ready. Now, that is the part of documentation. Now, to initiate criminal prosecution and disciplinary punishment, there are two things. Understand this. Say, for an example, you are working in an office. A co-employee comes to you and asks for a sexual favor. You have not consented to it. Now, the moment there comes a consent that a woman is also giving the consent, then this law is not going to apply. Let me be extremely clear. But if a woman is finding it difficult or tough or unwelcoming, the first thing that she has to do is she has to raise a written complaint. That written complaint, she moves to the employer, or as I said earlier, to the bar association, with example to the lawyers. The moment that complaint is moved, the first thing the person entertaining your complaint has to do is has to take a disciplinary action. And what did that disciplinary action is? That disciplinary action, as per the Vishaka guidelines, is that for the period of 90 days, the perpetrator has to stay away from you. So it is as good as a civil injunction. So we can see from Vishaka guidelines that the person who is going to entertain your complaint is going to have a procedure, have the power of a civil court. So that is the first thing. But say, for an example, in the same case, you are working in an office, a co-employer approaches to you and physically, unconsensually attacks you in a way that gives color of a sexual harassment. Now, there will be two actions which are available over there with you as well as the person who is going to entertain your complaint. The first is disciplinary action, and the second one is he has to immediately file a written complaint to the local police station in order to register an FIR. This is Vishaka guidelines we are talking about. So yes, Vishaka guidelines are as it is taken down in POSH laws, only with minor changes with respect to the internal complaints committee. Now, the head of the complaints committee should be a woman and half of its members must be a woman. Now, this is not the POSH law. Understand this. This is Vishaka guidelines. So for Vishaka guidelines, whoever is going to take down your complaint, the person entertaining your complaint has to be a woman under Vishaka guidelines. It is the duty of the employer to aware employees of Vishaka guidelines. Now, it is a duty upon all the institution, all the persons. As long as there is an institute, they have to keep a lecture, they have to keep a special session, they have to keep a training session for the purpose of spreading the knowledge. Now, this has to be done on every 3 years. Understand this. So the time limit, I will be coming in the POSH Act. A third party, such as an NGO, should be involved to avoid any pressure from higher management of work. Now, the reason why Vishaka guidelines has stated that a person who is going to entertain your complaint has to be woman is very simple. A woman feels comfortable to share her problems with a woman. That is why the first person who can be the best person to have a safe hearing is woman. And the second, that in case that person is biased, she has to be assisted by a person from an NGO, or that person should be from the external committee who has no connection with the said company or the employer, and that person can be a lawyer. And understand this, they are supposed to be given the remuneration, they are supposed to be given the fees which is prescribed under their own guidelines and their own laws. The victim does not bear the fee, neither the accused. So this is a very important thing. One important factor which you have to understand is Vishakha guidelines also had a provision of compensating the victim. So Vishakha guidelines are as it is enacted in the POSH law. What different is in POSH law is only the working committee, the tenure fixed, the structure of fee fixed, the powers given as a civil code, and one important factor they are given is just in case an employer or a company or an institute does not have a working committee, then the victim can approach the district authority. And who is the district authority? The district authority, my friends, is the district magistrate. Now, for saying for the purpose of Pune, the district magistrate or the woman redressal cell, the head of woman redressal cell is appointed by the district magistrate to work as a internal complaints committee head. So you have to understand. So just in case if you are working in any company, you're working in any chamber, you're working in any office, you're working independently and there is no internal committee, you can directly approach the woman redressal cell. So you have to understand this. I hope I'm clear till now. We can move to the next slide, please. Now this is the POSH Act. Now we talked about the Vishakha guidelines case for the year 1995 when the judgment actually came. Then we talked about the CVI investigation, which was still in subsistence till 1997, which also eventually came to be in favor of the accused persons itself. But we have the law of Vishakha guidelines in 1997. It takes another 16 years for the government of India to form a law, and that also did not happen overnight because that had to have 10,000 incidences of similar nature. And the shocking incidents that shook the entire of India was the case of Nirbhaya gang rape case, which all of you are aware. So how many more victims were supposed to be fallen for a law to be introduced? Now that is part of debate. Now you can always raise these questions in the essay writing competitions whenever you participate. The second thing is that the parliament received the precedent not immediately on 22nd of April 2013, and then the law was enacted, which consists of 8 chapters and 30 sections. The law is very precise. I would recommend all the lawyers to go through the entire act. It's very simple. It's entirely based upon the Vishakha guidelines, only with the minor changes, which is good. And there was a recommendation from the sitting parliament members that POSH Act should be gender neutral. Understand this. Men under Article 15 are not given the special status or the special provision that equivalent to the woman, because we still belong to a patriarchal society. Now that is also another form of debate which you participants can raise in your essay writing competition. One thing you have to understand is POSH Act is gender neutral only with respect to accused. There is a difference. So if a female employee files a criminal complaint against a perpetrator who is male and that male is assisted by a female, the complaint under POSH is maintainable against that female also. It is gender neutral in that context. However, the complainant cannot be a man. The complainant can be a man working for the benefit of woman, but not for himself. So the definition of gender neutral with respect to POSH Act is different. So you can always raise that debate. Now, as I stated, that it extends to the Article 15. We can go to the next slide, please. These are the overview of the chapters. It is available in the book, but just to give you a complaint, you can file a complaint. A victim can file a complaint under Chapter 4, and the enquiry is given under Chapter 5. The duties are given under Chapter 6. The duties of district officer. My friends, I told you that when there is no committee, no internal committee, no committee working, at that time, the victim can approach the district officer. This district officer is district magistrate. District magistrate has given the powers to the woman redressal cell, which is working in the Commissioner Office, Pune, as of now. And the miscellaneous ground, which you can go through the act. Going down. Now, these are the technicalities. We will definitely be sharing this PPT. Ruchi ma'am will be sending the PPT in the group also. Don't worry about that. So these are the technically. Who can raise a complaint? All women victims can raise the complaint, either in private sector, public sector, or any sector where that victim is working voluntarily, as I stated. What is the role if a victim is a transgender? Sorry, I missed that question. We would come to your question immediately after we end this, so we can keep that in motion. Yeah. Then the applicability only extends to women and women workplace. Organization of 10 or more employees to have internal complaints committee. Understand this. The difference is when there are at least a group of 10 people working in an institute, you have to have an internal complaints committee. Say for an example, if you don't have the internal complaint committee, where do you file the complaint? Then at that time, despite not having the ICC, that institute has to rely on Vishakha guidelines. So both things are in place. So understand this. There is no as such a compulsion upon an institute to have a ICC. They can still have the guidelines of Vishakha. But having the guidelines of Vishakha is mandatory, because in absence of which it will be a negligent act on part of the institute. So understand this. Organization of less than 10 employees to refer complaint to local complaints committee. Now, who is this local complaints committee? As I said, the local complaints committee is headed by the district officer. This district officer is basically the district magistrate. The district magistrate entrusts this power to women I'm sorry, tough words coming from my mouth. Redressal committee, women redressal cell, which is in Commissioner Office Pune, but it can be different in other localities. Say for an example, an incident has taken place in village, a Gramin, as in it is not in the jurisdiction of a city. At that time, the superintendent of police has the authority to entertain this complaint, and the superintendent of police will have to appoint another lady officer to look into the matter, because that is the first requirement of the POSH Act, that the person entertaining the complaint has to be a woman. So understand this, which is the, we will come to the questions in 5 minutes, don't worry. Now, the redressal committee to have 50% of the women as members. Now, giving you a simple calculation, if there are 10 persons working in an institute, you have to have at least 4 persons entertaining the ICC, the Internal Complaints Committee. Out of these 4 persons, the chairperson has to be a female. So already 25% of the job is done. Amongst the remaining 3, you have to have 1 more female. So that is how the 50% of the women workers become members. Now, who has the authority to appoint these members? The 10 persons will have the opportunity to vote who they want. And in order to avoid, say for an example, the corruption in that committee, amongst those 4 persons, 1 person has to be a person belonging to the NGO, or he has to be belonging to another committee, which is either lawyer, NGO, NALSA, legal aid services, any person who is working externally. Now, 4 persons, 1 person to be externally. Amongst 4 persons, 2 of them have to be female, 2 of them have to be male. And if that external person is a female, then the remaining 2 persons can be belonging to the male category. But there is no compulsion of having males. Understand this. So all 4 peoples can belong to the gender of women. Now, if organization does not have internal committee, then Vishakha guidelines to be followed, as I already stated. We can go to the next slide. Now, this is a procedure which I have already stated. This is basically the tenure, the fees that has been stated. I have already argued on that. We'll move to the next slide. Now, this is the procedure. If an incident happens with a woman victim, she has to file the written complaint within 90 days of the last day of incident. Say for an example, if the action is still in motion, say for an example, it ceases to be, the last date of incidence is 1 January 2025. The last date that she can file complaint is basically 1 April, 90 days. She cannot go beyond that date, because then if she has to go, she has to explain the delay. And this, my friends, is keeping with respect to the civil procedure codes, that a limitation law has been in motion. Now, the delay can be condoned because the committee will have the authority of a civil code to condone the delays, but they have to be on genuine grounds. Now, under POSH Act or under the Vishaka guidelines, monetary settlement is not permissible. During the course of our practice, we have come across cases where the women who want to exit from the company and they are under a contract with that company, they mischievously try to file a criminal complaint under the POSH Act against the male employees in order to get the benefit of a leave of 90 days. And that has happened previously. And the objective behind filing such a complaint is to bring down the perpetrator or the company for monetary settlement in order to save the image of the company. Such complaints cannot be entertained. Monetary settlement under POSH Act is impermissible. It cannot be permitted. Yes, if you are honest, if the victim is honest, she is eligible for rightful, fair and reasonable compensation, but no monetary settlement is permissible. There is no clause of amicable settlement. There is a clause of disciplinary action which will have an amicable settlement that does not involve money. So understand this. Now, if no conciliation is reached, the internal committee will forward the complaint under section 509 of the IPC, or say for an example 79 of the BNS of the new law, to the local police station, and the local police station will take a criminal action. So there is no bar as such providing interference from the police, but there is a law that at first any such incidents that takes place and which can be resorted with counseling, then there has to be the POSH Act in place. Now, I hope the procedure is clear. Now, these are the notes on the next slide, which you can go through. These notes are basically for the purpose of what happens after the case is settled or what happens after the procedure has ended. So all these notes will be shared to you in WhatsApp. Then next slide. Now, these are, my friends, the other legal remedies, which most of them are, all of you are mostly belonging to the lawyer family. So I won't be going into the details. These are the section based upon the BNS, because the older acts included them under section 354, 354A, B, C, and D, and 376. However, now, as per the new law, it is section 74, 75, 76, 77, 78, and 64. One important thing. I started the lecture by stating that whenever a woman victim alleges a fact of rape, that fact has to be considered true for as long as the accused proves otherwise. So a court has to presume that a rape has taken place because the accused has the burden to release. Therefore, that as per the new BNSS or the new Indian Evidence Act, that is section 119 of the Bharatiya Saksha Adhiniyam. So understand this. So 114A is now 119 of the BSA. Next slide, please. Now, these are the 5 important cases that are worth the debate and worth the discussion, and which were basically the important part of today's lecture. The first case is Apparel Export Promotion Council versus AK Chopra. I have given the citation. In this case, the Supreme Court expanded the definition of sexual harassment to include any unwelcome act. As I said, to have the sexual intent, the time is not important. The intent itself is sufficient. That is the explanation given in the case law. The second case is Medha Kotwal Lele versus and another versus Union of India, in which the court stated that the Supreme Court emphasized that states should follow the Vishaka guidelines and ensure they are implemented effectively. The court also stated that victims can approach the high courts if the guidelines are not followed. Now, interesting factor. There is no ICC committee. The police are also not entertaining anything. Now, where does the victim go? The victim can directly approach the Honorable High Court. That is the case law. And the High Court will then interfere in the matter, because Vishaka guidelines are not symbolic. They are existing in nature. ICICI Bank versus Vinod Kumar. In this case, now it is an interesting fact. Now, we were talking about a sexual harassment a woman is undergoing through a workplace. Now, I gave you the example of a lady advocate working in court who is technically working independently, but still getting harassed by somebody. What does she do? Or in a company where there is a female employee and she is being harassed by a person who does not work in that company. What does she do? Whether the POSH Act extends to that or does it not? What does she do? Then the Honorable Supreme Court has stated that it does extend to the people who are not directly employed by the said company, but are also on contract basis or have a connection directly or indirectly. This my friends, is an extensive definition, and all the persons who are going to write an essay and participate in this beautiful competition, you can go through all these judgments, so you get an idea where you can lead your essays to. Now, in the case of Vinita Srivastav versus Sahara India Real Estate Corporation Limited, this case emphasized that the need for employers to adopt a zero tolerance policy towards sexual harassment at workplace and take effective steps to prevent and address such incidences. Why this case came to be, dictated is because what usually happens is a person who goes and harasses a female victim, and if he is easily let off, that boosts the morale for him as well as the people with same mentality working in that same company. And what they try to do is, oh, it's so easy, we have to simply harass somebody. If she gives the consent, it's fine, it's a lottery. If she doesn't give a consent, then we are going to get escape route, we are going to be forgiven, we are given to be counseled, and we are given to be a warning, and we are going to be let off. That should not happen, and that is exactly why, my friends, there has to be a zero tolerance policy. And one interesting case, the reason why we have discussing this case of Nana Patekar case is because an incident was stated by the actress against Nana Patekar, which was way back in year 2007. She filed the complaint in year 2019 when the Me Too movement was in motion. The magistrate refused to entertain such a complaint because technically at that point of time it was barred by limitation, because the maximum imprisonment for sexual harassment at those days was 2 years, and prior to the criminal amendment law of 2013 the punishment was 1 year for sexually colored marks. In such circumstances, the Me Too movement, no court is denying the fact that women have gotten harassed in the past, and they have had the courage to approach and file the complaint belatedly, which is also not in denial, which is in fact a good thing. And people who have gotten harassed in the past should come up and raise their voice, because we need that. This message should be clear that no person has the authority over a female. But then law cannot be twisted on social issues. The law has to be followed, and because Article 21 extends to the right of accused as well. And that is exactly why the court refused to entertain a complaint at such a belated stage, because the law is equal for all, and even the accused under our law have the right. Now, after I have discussed all these cases, now we are all advocates. I still believe that we discuss the cases, we discuss the Vishaka guidelines, we discuss the POSH law, but something as advocates and as officers of the court, one thing is always going to remember, we have to remember, and we have to remind ourselves that Bhavri Devi still seeks justice. And I believe no other person should ever replace the shoes of Bhavri Devi. So we as advocates, please be active. I'm not saying that if you are appearing for the accused, you just leave the matter and fight for the victim, because that is unprofessional after all. But whenever you get a chance and whenever you get an opportunity to represent a Bhavri Devi, please make sure no such incidents ever happens, because if we do not stop it here, then we are going to lose it. So yes, this was the end, Ruchi ma'am. We will go to the last slide, and justice awaits. This is my personal opinion. Bhavri Devi deserves justice, and may her case reach a healthy conclusion. And that is end of the lecture. I thank you all. I thank you, Ruchi ma'am. I thank you, Abhishek sir, for giving me this opportunity to be here. Having the atrocious case that we have discussed, I just believe that everybody would relate. You have a beautiful topic to write your essays upon, and I believe now I can see that most of you people are shown interest in the Women's Week. So we need women upliftment, and thank you all. So we will go through the questions now. Ruchi ma'am, we'll go discuss the questions.
Thank you so much, Pushkar sir, for this eye-opening session, and it was really quite informative, quite